Mr. Chairman, we are live.
All right, welcome to the March 22nd day of the Judiciary Committee, House Committee meeting. Kay, will you please call the roll?
Representative Crago.
Here.
Representative Larson.
Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Williams.
Here.
Vice Chairman Washut.
Here.
Representative Yin.
Here.
Representative Swanitzer.
Here.
Chairman Olson.
Here.
Mr. Chairman, you have 9 people present and none absent.
All right, that's how we like to hear it. So we're going to be looking at some Senate files today. Our first one will be Senate File 87, and then we'll look at Senate File 155. Senate File 87, Voyeurism Amendments. We have Senator Cost, Representative Vice Chairman Duncan, and welcome Vice Chairman Newsom as well. All right, Senator, take us away.
Thank you, Chairman Olson and committee for taking this on today. I appreciate it. I'm going to start out at Senate File 87. Before I get into the actual bill, I want to say a couple of things. Ladies and gentlemen, technology has presented us with a world we can hardly imagine. We have dancing robots, which look like real people. We have automated cars, which we talked about yesterday or a few days ago, and the statute needs updated. It is time to better protect our citizens. Imagine going to a motel room and thinking you were in private. An act of intimacy happens on top of the bed. Up in a corner is a camera the size of an eraser on a pencil, and it's carefully positioned. It videos or takes pictures of the time. Voyeurism? I think we would all probably say yes. What if you were under the sheets? Voyeurism? The statute covers that now. With that, I'd like to do some explanation here. The voyeurism bill, an act relating to crimes and offenses, amending the elements and penalties of the crime of voyeurism, authorizing the imposition of specified probation conditions for those persons convicted of voyeurism, making conforming amendments and providing for an effective date. If you look on page 1, line 9, the things that are affected with these amendments, Wyoming Statute 64304A, the intro, and Romanet 3, by creating new paragraphs, Romanet 5 and Romanet 6, B, Part B intro, Romanet 2, and by creating new subsections, Romanet C, and that goes through F. And 713-304, by creating a new subsection, E, are amended to read. So we start on page 2. As we go through the first part of it, it says, except as otherwise provided in this section, a person is guilty of a misdemeanor punishable by imprisonment of not more than 6 months, a fine of not more than $750, or both, if he, without the consent of the person being viewed, commits the crime of voyeurism by looking in clandestine, surreptitious, prying, or secretive natures into an area where the person being viewed has a reasonable expectation of privacy, including but not limited to. 1 was already in there, Romanet I, or Romanet small I, restrooms, Romanet 2I, baths. Those were both in there, so they're not listed. Romanet 3, showers, was changed by the removal of or. And Romanet 4, dressing or fitting rooms, was already in there as well. Then the addition of Romanet 5, bedrooms, with a semicolon and or, and then 6, under the clothing being worn by another person, regardless of whether the person is in a place where a person has reasonable expectancy of privacy. Then on 20B, except as otherwise provided in this section, was added. A person is guilty of a felony punishable by imprisonment for not more than 2 years, a fine of not more than $5,000, or both if he, Romanet 2 on page 3, uses a camera, video camera, or any other recording device. On line 5A, for purposes of observing, viewing, photographing, filming, recording was added, or videotaping the intimate areas of another person. On line 9B, under the was removed, under clothing being worn by the other person, and was then added. And line 12C was removal of all of the wording except without the consent of the other person. Then down below that, on the small c, a person who is 18 years of age or older who commits an offense as specified in this section for which the victim is less than 18 years of age shall be guilty of a felony punishable by imprisonment of not less than 5 years and fine not greater than $5,000 or both. On page 4, we have D, a person who commits an offense as specified in this section who has previously been convicted of an offense under this section or of a similar offense under the laws of another state shall be guilty of a felony punishable by imprisonment of not greater than 5 years, a fine not greater than $5,000 or both. Line 9E, in addition to the penalties specified in this section, a person guilty of the offense of voyeurism shall serve a term of supervised probation of, on line 13, Romanet I, 1 year for a violation of paragraph B, Romanet 2I of this section. And then on line 16, Romanet 2, not less than 1 year and not greater than 2 years for a violation of paragraph B, Romanet 2I of this section where one or more photos, video segments, or clips or other images of media of the victim are disseminated to another person or posted on the internet. Or on page 5, Romanet 3, not less than 3 to 5 years for a violation of this section where the victim is less than 18 years of age at the time of the offense, notwithstanding Wyoming Statute 713-302B, and I'll let you know that that is for when both are under 18. And so that's the provision that protects our 18-year-olds, or at least says, okay, these people are not fully developed in their brain, so we're going to give them a little less penalty. Line 6F, as used in this section, intimate areas means any portion of a person's pubic area, buttocks, vulva, genitals, female breast, or undergarments intended to cover those portions. Intimate area does not include intimate areas visible through a person's clothing or intimate areas knowingly exposed in public. And then down on line 13, 713-304, imposition or modifications of conditions, performances of work by the defendant. 16E added in was as a condition of probation or suspension of sentence for a person convicted of an offense under Wyoming Statute 64304, the court may require a defendant to complete successfully a sex offender treatment program. And then the effective date would be July 1 of 2021. And it's known that a lot of the people that are involved with this end up with going further at a later date. And so that's why that possible sex offender would be considered there. And with that, I really have nothing other than answering questions, but I would like Representative Duncan to read, if you're okay with it, to read the testimony of the young lady that had asked me if I would consider bringing this bill forward. If you're not wanting to do that before answering questions, I certainly will entertain it either way. Your choice.
Yes, Senator, let's see if we have any questions for you, and then I'll consider that from Vice Chairman Duncan to be testimony. So we'll certainly take it.
Thank you.
Let's see if the committee has any questions. Representative Oakley.
Thank you, Mr. Chair, and I saw some discussion going on down there, so if you guys are maybe seeing some of the same concerns. My concern has to do with, okay, so page 3, line 20, it's got to do with the punishment sections as specified, and I'm assuming you, so I don't know if you meant to or not, but page 3, and maybe you did, I'd like clarification, page 3, line 20, that would make it a min 5. So is that what you're wanting? And then we would need a top.
That was amended by the standing committee, and that was a recommendation to match up to, I'm sorry, I should have said chairman. That was to match up to other penalties so that they were consistent in what they were doing.
So to clarify, you that is intentional, that this is that's a min 5 felony?
It was with a student, with somebody under the age of 18.
Okay. Then I'd have to look at it. I think then you have to have an upper amount. So if you do a min 5, max 20, let's say, I think that has to be there. So
Sure.
I don't know if that was discussed, but that's something, anyway, something that I'll have to look at. You do have to have a term, so if there's a min, then, and then, so the same thing. Page.
Representative Oakley.
Oh, I'm
I
sorry.
know it was a long weekend, but let's go through the chair.
Okay, sorry, Mr. Chairman. Can I ask another question?
You may.
Thank you, Mr. Chair. Page 4, lines 9 through 11. Again, so was it discussed that it specifically is mandated that it's supervised probation, meaning that it's suspended rather than an imposed?
Senator Cost.
Chairman, Representative Oakley, the idea of the term of supervised probation would be, I had interpreted it as mandatory. So if that's what you're asking, I might misunderstand what you're asking.
Representative Oakley.
Thank you, Mr. Chair. Yes, I don't know that I can think of any other place where if you've got basically as a punishment that they can have a term of, so punishment is usually, a form of incarceration or a fine and then from there, it's left to the judge's discretion on whether it's imposed or suspended in favor of probation. So I don't know that I've seen this wording or language used where it says shall serve. I don't even even a term of probation. It seems it's just a little different to me to be mandated that it's probation. I can't think of anywhere else where I have seen that.
And would you agree?
Yeah.
Not being a lawyer and knowing from further witnessing of the representative working with another bill, I'm very aware that she's a lawyer. I'm not going to push that issue because I'm not aware of it. So I certainly would lend that to those that have more knowledge in that than I do.
I trust that Representative Oakley is right. But just I think to clarify here, what Representative Oakley is trying to figure out is let's get to the intent of that supervision. Is the intent of this to mandate supervision after release of a full sentence? Or was the intent to make sure that there was a minimum of supervision if release occurred early during the sentence? So in other words, you're sentenced to 3 years, you serve 3 years and then have the supervision. That's the intent versus what I think Representative Oakley is saying you would, if you had an early release, then are you trying to mandate a minimum release during the mandate a minimum supervision during the early release?
Mr. Chairman, I understand that. And this was in my mind to be at the end of a year or if whenever that penalty was, a probationary period to make sure that we've got corrective actions taken care of so that this doesn't escalate into something worse.
And that actually, so that helps me with my main question then, because my main question is, why is it 2 years I know that's the existing statute, but why is it 2 years? If for our, we'll call it our basic offense, because if we involve minors, we want it to be a minimum of 3 years to 5 years, which is conflicting with the other paragraph that says we want it to be a minimum of 5 years, and then 1 year supervision. So why not set the felony provision higher than 2 years? Because of, I think the discussion of where Representative Oakley was going with that, or at least where I wanted to go with it, was if you're sentenced to 2 years, you don't serve 2 years in prison, right? Because you're very unlikely. You're going to get an early release. You're going to serve less than 2 years in prison for the offense. And then you're going to have you're probably going to have a year, maybe to a year and a half, but you're probably going to serve a year of your 2 years in prison. You're going to be out on release, on parole. So knowing that that's the case, this is one thing I just struggle with in general in our sentencing laws, is that at least for the public to understand that when we think I think this is a very serious offense, Senator Cost. I don't think 2 years is enough. I don't think that 3 years is enough when it's done to a minor. So I think the message to the public should be very clear that when we say we're sentencing someone to 2 years, are we really sentencing them to 2 years, or are we sentencing them to 1 year? That's my fear.
Mr. Chairman, I side with you on that. The thought as we were putting this together was because there had not really been anything prior to this for this nature, that we take it not too abrupt at the beginning, because we were afraid that might turn some people off. This is a pretty serious offense, and it's definitely something that you knowingly are doing. And because of that, I would not have a problem with an amendment that says make it 3 or even 5. I mean, I do not have a problem with that. I just cited on the idea of let's not go too far too quickly so that we don't end up killing something that might be there. So,
and then, and the other question I have is when I compare let's just call it the consent portion of the misdemeanor and the felony. On the felony, the basic felony, it becomes a felony when it is done, under the clothing, and it is done without the consent of the other person. Versus the misdemeanor, we use completely different language. Instead of consent, we talk about it being done under the clothing, regardless of whether the person is in a place where the person has a reasonable expectation of privacy. And just help me understand why we're not worried about, why not use consent in both scenarios? Because it seems to make sense whether you're filming. Why does it change all of a sudden? You either have the individual's consent or you don't. And when you don't, it's a crime, period. That's at least how I view it. And I think that's how every other person who's not a lawyer and not inside this Capitol would view it. Just on the street, they'd say, well, if you didn't have his or her consent and you took a picture or filmed under their clothing, that's got to be a crime. And then the level of the crime, whether it's a misdemeanor or a felony, may depend on the type of filming that occurred or where it occurred. But why not? Why? What's the logic behind that?
One of the lawyers that was advising me from a part of the state who's done a lot of this said you didn't need it in both places. And I said, okay, I'm not a lawyer. I'll do as you say, but I don't have a problem with putting it back in either. So,
and that might be a question for Representative Oakley. Maybe that is intended, when you get rid of the consent provision on the misdemeanor, is that intended to make it easier to prosecute? Because you don't have to put a victim. I mean, how do you figure out whether you had consent or not? Is the only way to do that to put the victim on the stand? If so, then that makes me uneasy with the felony provision. I don't want it to be so an impediment to prosecution. Representative Oakley.
Thank you, Mr. Chair. And two different things I think here, as far as I think what that was getting at, probably via some testimony. I did see some of it from the Senate. The consent portion there being an obvious that people are taking all sorts of videos of themselves in different ways today, and we're trying to not broaden it too much. I'm assuming, is that fair, Senator Cost? My thought is this, for discussion and then see what I think that maybe I can take a second, do a quick amendment that would just make it the punishment language more conforming to what we see in criminal statutes. And then see if Senator would like to weigh in, and if our committee's all right with
So I'll ask lots of questions, which will give Representative Oakley enough time
that.
to work through language.
We could hear.
Other questions for, Vice Chairman Washit, your hand was up.
Thank you, Mr. Chairman. Good morning, Senator. Welcome to Judiciary. My question deals with page 5, line 16 through 19, where you make it a discretionary decision on the court to order that the offender complete a sex offender treatment program. So two-part question. Number one is, do you want these offenders to be included in the sex offender registry? And number two, are you aware that some studies, sitting in my hotel room last night with nothing better to do, I started reading about voyeurism and sex offender treatment programs. And a study back in 1985 showed that these researchers looked at 600 cases of voyeurs, and all 600 of their participants had committed other sexual crimes, including rape. And so I'm just wondering, I agree with you that voyeurism is a serious matter. Your thoughts about including these offenders in the registry?
Senator Cost.
Mr. Chairman, Representative Washit, you guys are targeting exactly what the initial was between the person that had asked me about this and myself. And as we worked with LSO, please, I'm not knocking anybody, so I don't want anybody to take it that way. It was suggested that we don't quite go that far because it's new and it's never been in any of the previous information of voyeurism. And they said this would be a totally new step to say that they need to be considered as registered sex offenders. The other thing was, you're not, as I understand it, to tell a judge what they can and can't do, so you can suggest to a judge what they can and can't do, is what it sounded like. And so the bottom line for us was, okay, if we can get this in, we'll worry about the rest of it later. But right now, something needs to be done to protect innocent people from what's happening. So that's really where I stand on it. I mean, I am certainly not opposed to stronger sentence to that, because I think it is a problem. And I also know that exactly what you've said, it does lead to other action.
Yeah, and well, Senator Costa, a couple of things there. Number one, I think there's definitely loopholes in the state of Wyoming, which is what you're attempting to close. Obviously, I think that's one part of it. But I think it's more than just loopholes. I think it's a rampant occurrence, not just in the state of Wyoming, but across the country, that I just don't think that, maybe I could say this for most states, but absolutely Wyoming hasn't taken a hard stance on voyeurism. And that's why you have these knuckleheads running around with phones, when you talk about putting a pencil-sized camera in a hotel room, that blows my mind. And this one thing to be in the hotel room, it's another thing if you were to place that in a bathroom where my wife or my children are going to go. So I think I respectfully, but fundamentally disagree with, taking it slow. I think we ought to do it once and do it right. And send the right message to the public that the public deserves. With respect to whether, we tell judges to do what to do or not, there's a little bit of flavor of that in this bill, which actually I'm not in favor of. On page 5, lines 1 through 4, for example, it does just that. It says the sentence shall be not less than 3 to 5 years. That tells a judge exactly what the judge has to do. So, I think, to that point, if that's the guidance you received on other portions of this bill, I think I don't know what the point of that guidance was, because This bill is doing that in some respects, and we do that sometimes in law called mandatory minimums and maximums. I think that's what Representative Oakley was getting to on the 5-year and whether you have to have a ceiling. Those are policy choices, absolutely. That's why I'm suggesting that maybe we just ratchet up the minimum penalties on all of these. 3 years for filming someone who's under 18. So you're going to tell me that when someone puts a camera in a bathroom and films my 9-year-old daughter that he gets 3 years in prison and gets released on 2 years, and that's justice? I don't think so. So I think we're tracking in the same field that I'd rather see those ratcheted up. I think those are serious sexual offenses. And whether they should be on the registry or not, I'm actually surprised it's not on the registry for a felony or when you film a minor.
Mr. Chairman,
Senator Cost.
I do not argue with you at all on that, any of that. I mean, I am totally in agreement there. And when you hear the testimony, unfortunately, the young lady who had asked me this was not able to attend this morning because of her job. And so Representative Duncan will reveal some stuff that I think will be very eye-opening to exactly what you're talking about. Exactly what you're talking about.
And the other reality is, I look back at, I'm just looking at the history of your bill, unanimous through the other chamber.
Yep.
So I don't know if that means that this was this was just fit just perfect to get the entire body on board, or I think what it means is that other chamber down the hall agrees that this is something we need to be serious about. So I don't think that ratcheting some of these penalties up and sending it back to your chamber would hurt your bill one bit. I bet it comes back unanimous just as quick.
There may be a couple, but I don't think any more than that. So,
okay. Representative Williams.
Thank you, Mr. Chairman. Thank you, Senator Cost. I had the similar questions that Representative Washit had, and concur that my attention was drawn to page 5, line 18, the may versus shall. And I too would like to see shall and see sex offender register as well. My only question is, I'm unfamiliar with the program itself, the treatment program. Would the costs of that program be incurred by within the court system, by the offender?
Senator Cost.
Mr. Chairman, Representative Williams, you're asking a question there that I'm not familiar with. I don't know whether that cost, just exactly where that would come from. But the shall and the may, I'm certainly not going to argue on that. That's for sure.
Yeah, that's just Representative Williams, and maybe help me understand where you're headed with this. So when we're looking at page 5, line 18, the may versus a shall, we're talking about the misdemeanor in that paragraph. So it does sound like maybe the felony is automatic. That's why it's not addressed in there. Or why don't we address the felony? Why do we give the option for the court to provide why do we give the option for the court when it's a misdemeanor offense? That's 6-4-304. Or is the felony under the same statute? The felony's under the same statute. My apologies. So it is the felony and the misdemeanor.
Mr. Chairman, I was going to say, I think it was for all, not just, but I really think it was intended for the felony.
Senator Cost, other than it's just what we do, why is the effective date July 1? Is there a reason why we can't just have it go into effect when the ink hits the paper from the chief executive?
It was just put down as July 1, and I didn't have a problem with that. So
okay.
Immediately would not be a problem either.
Representative Crago.
Thank you, Mr. Chairman, Senator. So my question pertains to the definition of intimate areas and why that was included within your bill. What was the purpose of defining that out and including that as an element on page 3?
Senator Cost.
Mr. Chairman, Representative Crago, the reason for that was last year there was a voyeurism bill that came through, and the lack of clarity in it was making it difficult for people to accept it for prosecution or to move forward with it. So the attempt was to make sure it's pretty clear as to exactly what we're talking about here. And that was the whole purpose of it.
Representative Craigo?
Mr. Chairman, thank you. And I asked that question because I think as I said here, I believe the purpose of the bill is to expand the scope of what is covered under voyeurism. But I think that actually limits it. And I think it narrows down the statute that by including that definition, it narrows down what we already can prosecute under voyeurism. And I say that, and I'll give an example. For instance, let's talk about Joker in the grocery store capturing an image upskirt. All right, let's take that example. And the woman happens to have on underwear. That wouldn't qualify because that would be a loophole for him. He'd say, I wasn't intending to capture an image of an intimate area because she had clothes on and it's over the clothing. And so my question is, do we need that definition in there or not?
When Senator Cost, Representative Craigo, I think the definition says intimate area means any portion of a person's, go through the description, or undergarments. So I think that would include the woman's underwear. Just simply, that's the intent of this definition, is that you can't use that as a loophole because that is a loophole in the current law. Or are you saying? What are you saying, Representative Craigo? That definition,
Well,
doesn't cover undergarments?
it does as it's written, I guess.
Okay.
And I'm just concerned that it may narrow the scope of the bill or the law, voyeurism law as it stands. And maybe I'm asking the question. I'm accepting that I might be wrong. I normally am. So that's just my concern by adding that in. I don't know if we gain anything, I guess, is what is really my question. Is it necessary? If you're taking a picture under somebody's clothing, which would be covered on page 2, lines 16 through 18, if we're taking a picture under somebody's clothing, do we really need the definition of intimate areas? Because it's already covered by saying you can't take a picture, record, or view, actually. Whether you take a picture or not, it would be covered under 16 through 18 on page 2. That's my question.
Senator Cost?
Chairman Olson, Representative Craigo, what you're talking about, there's an exact example of, and that is in a town to the west of us and a town where a university is. In a town west of us, it was not prosecuted because the current voyeurism bill, they felt, did not cover such. And in a town where there's a university, it was felt that it did, and it was prosecuted there. So this was to try to eliminate that difference of opinions between prosecutors in trial time. And that was the example that started some of this as well. And that's the best answer I can give for that.
Representative Craigo?
And maybe I'll try to clarify my question.
Sure.
And I apologize if I'm confusing the subject, but I just feel like, and maybe Senator Cost can address this. I feel like by adding that definition in there, we're requiring prosecutors to prove intent. If you just read it as it's in the statute now, for the purpose of observing, viewing, photographing, filming, or videotaping another person. And once we add the language intimate areas, now we have to prove intent that they were intending, and we can do that by circumstantial evidence. I'm sure Representative Oakley could do that, no problem. But I'm just worried that we are narrowing the scope of what we cover under voyeurism, and it may add an extra level of proof that doesn't already exist, which I know is not your intent. And so I guess I'd ask what you think about that and whether or not it's actually needed.
Senator Cost?
Chairman Olson and Representative Craigo, My concern is that we make sure that it's to the point where we can get prosecution and not end up without prosecution. If there's a need for something in the future, because there's a finding of a loophole or something, then I guess that would need to be corrected. But because of where the voyeurism bill is right now, and the fact that it is inconsistent, and the prosecuting attorneys have said that they do like this bill, they're very supportive of it, leads me to think maybe that's a better way to go. But again, that's my opinion.
Senator Cost, to Representative Crago's point, that, and back to one of my initial questions, that's kind of where I'm struggling with whether we are, when we're tacking on this without consent for a felony and on a misdemeanor without a reasonable expectation of privacy language, same exact issue. And I'm not a prosecutor, so I don't know. But if you have to prove this intent factor without consent, that this statute now also would force the prosecutor to prove that. And I don't know. My question is, how do you do that when let's use the tattoo parlor example, your tattoo parlor, a woman goes into a tattoo parlor and she says, I would like a tattoo in my intimate area. And he says, okay. And so, but he films while he's doing that. And now so now he goes and puts that on the internet. The question is, can we get him for a felony voyeurism? Because in my mind, automatically, I'm sure she didn't consent to him filming it, and putting it on the internet. But how does the prosecutor prove that? The prosecutor puts, other than through circumstantial evidence, particularly, is my question, because otherwise you have to put the victim on the stand and say, did you consent to this man filming you and putting it on the internet? And I don't think most victims are going to want to be on the stand. Some may, but the circumstantial evidence portion becomes important, because I want to know that our prosecutors feel comfortable that they can prosecute that dirtbag without the need to put the victim on the stand. And then so you don't get into the whole argument of, well, she consented to the tattoo. She consented to, I was right there in the intimate area with my tattoo gun. And then everybody knows in this community that I have a camera for training purposes in my tattoo parlor, or whatever he says, right? So, and maybe we'll need to hear from some prosecutors. Maybe that'll be helpful, but I understand that they're in favor of the bill. I hope they are, but I think where Representative Crago is headed and where I'm headed with this language is, I don't want to create the extra impediment. I want to get rid of the loophole. Senator Cost.
Mr. Chairman, I'm certainly not going to argue with on that. I will yield to you guys, because as lawyers, you know more where you're going with the direction than I do. I just want to make sure that we get a quality bill that can protect people, because it's time to protect them. And so whatever we do decide, I hope protects these people that are being dealt with in an unfair manner.
All right.
So
Thank you, Senator Cost. Representative Provenza.
Thank you, Mr. Chairman, and thank you, Senator Cost and Representative Duncan, for being here. My question, going back to the sentencing, is there a reason specifically why we have the mandatory minimums in there? I know just in my county, my district court judge says that 99% of crimes don't have a mandatory minimum, and that allows for judicial discretion in sentencing. And that's something that is seen as kind of like a Wyoming value. So I'm just curious if this is modeled after another, or if there was a specific discussion about like the term mandatory minimum on these sentences.
Senator Cost.
Chairman Olson and Representative Provenza, good question. I thank you for that. To be honest with you, we wanted minimums on so that the severity of this crime would be realized rather than going back to almost nothing. So it was one of those situations where if we don't have a minimum, a slap on the hand just really doesn't do much good. And so a minimum would at least have saying this is important and we need to look at, this is a minimum.
And Senator Cost, to that point, which goes back to my number one concern, is raising the sentences. Can't we we can get rid of mandatory minimums in this bill and solve that problem where we send the right message. Instead of saying not more than 2 years, if we say not more than 4 years, we effectively did that. We raised, without setting a minimum, we raise it we raise the minimum by raising the simple language in the statute. Instead of saying not less than 3 years to 5 years, we just say up to 5 years. And for a minor. And I just do not see a scenario where a judge in the state of Wyoming has a case where a minor's been filmed in her private areas and they sentence that person to 1 year or 2 years, when the felony for an adult is already 2 years in existing statute. So the mandatory minimum of 3 years doesn't seem necessary to send that message. It's just not going to happen. It would be inconsistent with a felony provision for an adult. So wouldn't you agree that we can send that message by simply raising these levels and not tying the hands of a judge?
Chairman
Senator
Olson, I don't disagree with that. One point that I would like to make right now, just so that everybody understands, for a person who records a telephone call, not intimate or anything, just a telephone call, the penalty is more severe than the voyeurism current penalties we have. So anything to make that stiffer, I am certainly not going to complain. But
Penalty, do you know, Senator Cost?
I knew you'd ask me that. I want to say it's like 3 years, but
Okay.
that would be me just
It's
saying.
a good point, though. It is.
But it is a good point, yes.
Vice Chairman Washington, and then maybe we'll take Senator Cost out of the hot seat and get some public testimony.
Thank you, Mr. Chairman. Just a comment on the language of consent. In an investigation, oftentimes we'll recover these cameras and recordings, and we'll have a lot of victims that we don't know who they are. And so if we have to prove consent to the victim or lack of consent to the victim, it's going to cause us some problems. And so I like the earlier conversation about finding a way around. We're not creating that consent requirement.
It's not always that the Vice Chairman and I agree on things, but when we do, we've got something coming from
Got
this
something
committee.
coming, yeah. Thank you, Mr. Chairman and Representative Washington. You're not going to hear any complaints from me. I mean, this is a serious situation that we need to work on. And so I'm in favor of whatever we can do that will make it better. So certainly.
All right. Committee, you ready for some public testimony? Vice Chairman Duncan patiently waiting to read us this testimony.
Thank you, Mr. Chairman. These are her words, not mine. And if she were here, you would only hear her voice. It is that impactful for her to not be able to show her face. So I'm going to read exactly what she sent to us and what she would have been saying today. I appreciate everyone taking the time to listen today. First off, I'd like to briefly explain the circumstances that has led me to being here today. In June of 2019, after taking a walk on my lunch break from work, which I did frequently, I returned to the office to change back into my work clothes. Most, if not all, of my coworkers knew that this was a common thing for me to do on my lunch breaks, especially in the summer. The women's restroom at the office was just a single room. It's not the type of restroom that has various stalls. Upon going into the restroom and taking my clothes off to change, I crouched down to remove something from my gym bag and happened to glance under the sink of the bathroom and noticed a fairly small round webcam looking back at me In sheer panic, I clutched the camera in my palm, not really know what to do. As I could feel a slight panic setting in, I quickly threw clothes on so that I could exit the restroom to find my boss. In the meantime, the person responsible for this crime had been hanging out nearby and saw me exit the restroom. He then deliberately looked in the bathroom upon my leaving and realized the camera was gone. My boss was informed of the situation and the police were notified. Said coworker did admit to the police that he had placed the camera in the restroom, but he claimed it was the first time and only time that he had ever done it before. The police ended up searching his workspace and located a memory card, which had contained over 100,000 images and video recordings, as well as audio recordings that were all located on the same memory card. The images in the video dated back to August 2018. It was very apparent he had been placing a recording device in that bathroom for quite some time undetected. The device showed him taking test images, ensuring that he was getting just the right angle and the placement of the camera. He ended up capturing images and video of 4 different female coworkers, one of them being myself, over the course of that year. I would imagine more images and video existed that were never recovered. It's sickening to think of how many victims he potentially had. The 2 counts regarding the audio recordings, which he admitted to police, he had also been guilty of. Also known, according to the Wyoming law, as intercepting communications, were dropped in exchange for his guilty plea to voyeurism. However, it doesn't make him any less guilty of those crimes as well. What's interesting to me is that the audio recordings that he captured, if convicted, actually carried a harsher punishment than the voyeurism counts did. Illegally recording a person's conversation without their consent carries a punishment of up to 5 years per count. For the crimes that were committed against me of voyeurism, the harshest punishment was up to 2 years in prison per count according to the current Wyoming law. How is it possible that illegally capturing a person's conviction without their consent can carry a stricter punishment than if you had video recorded that same person using the restroom without their consent? Therein lies the problem that I'm here to address today. Not only was this a humongous violation of privacy, to say the least, but according to the current voyeurism laws, this crime is not viewed as a crime of a sexual nature. A person who commits these types of crimes is doing so under no pretense than a sexual one. In my particular instance, the person guilty of these crimes did not place a random camera in a random bathroom, hoping to capture a random stranger without their clothes. I was targeted, as were the other victims that he violated in the same manner. He knows that I had to change my clothes in that bathroom upon returning to work. He knew about what time I'd be returning, and he knew when to place the camera, hoping it would go undetected like all the other times he had done it. He also strategically placed the camera in an opportune spot. I think anyone under the sound of my voice would agree that this was most definitely a crime of a sexual nature. Back when these laws were put into place, technology did not exist like it does now. This law was probably protecting innocent people from what we'd refer to now as a peeping Tom. However, in this day and age, and with the amount of technology available, the current punishment for voyeurisms is not enough. The people committing and being convicted of these crimes should be considered sexual offenders and a threat to not only their victims, but to everyone around them. If a camera can be placed in a doorknob or even a ballpoint pen, a camera can be placed anywhere. When it comes to cameras being placed in restrooms or fitting rooms, this is a serious problem that should carry a harsher punishment. I also think it's very important to remind everyone that this crime is sometimes viewed as just something that might happen to silly kids making dumb decisions with their cell phones and exchanging pictures they shouldn't have. like to make a point to say this crime committed against me was done in my workplace by a coworker that was in his 50s. He knew exactly what he was doing, and he did it without any regard for anyone but himself. This is not a matter of accident or happenstance, or of not realizing the gravity of one's actions. This was a blatant attack on my privacy and the privacy of others. I may not have been able to affect the punishment given to the person who forever changed my life, but the deceitful and heinous actions. But my goal today and moving forward is to give victims of these crimes more peace of mind than I received. Not only was he given the least amount of punishment for these crimes, but he was not required to register as a sex offender. In my opinion, he should be in a database with all other sexual predators that live among us. He should be considered a threat to society. With your help, we can provide justice to victims of these crimes. As it stands now, the people guilty of these crimes are getting away with mere slaps on the wrist for life-altering crimes they're committing against others. Just imagine if your wife, daughter, or mother had been violated in this way. What type of punishment would seem sufficient to you? I don't plan to stop. Hopefully, the changes made here today, I will continue to fight for myself and other victims of these crimes until there is a suitable punishment in place and required time on a sexual offender registry. Please help me take a positive step in the right direction to make these much needed changes. Thank you so much for your time, and I appreciate your listening today.
Vice Chairman Duncan, thank you for reading that story to us, because I think that just that testimony alone speaks to the questions that this committee was asking. As I hear that testimony, I hear 3 issues in the law. Unfortunately, I only hear that one of those issues in your bill is addressed. Only one. That's the loophole itself. But I hear a Wyoming citizen crying out for stricter penalties, more than the 2-year felony. This bill doesn't do that, but it should. I hear Wyoming citizen crying out to place people who commit these crimes on the registry. This bill may do that, may not do that, could be a little stronger in doing that. It sounds like, I think you want to address all of those issues, Senator Cost, and it sounds like maybe we can get there. But I hope we'll take some more public testimony, but I really think that, I think we ought to address that 2-year felony. And I think that's important. And I think we need to have a serious conversation about the sex offender registry as well. And I think we're getting there. All right. Additional public testimony online. Let's move to online. I have Jennifer. We're going to bring Jennifer in. Anyone else? We got Mr. Barron. Mr. Barron, you'll be up on deck next. Jennifer, you can go ahead and turn on your camera. Introduce yourself to us. First name, last name. If you represent an organization, let us know. And then please let us know what you want us to know.
Good afternoon, Chairman Olson and representatives. Like you said, my name is Jennifer Petrie. I am representing myself and the citizens of Wyoming. I don't represent any group. I've logged on today to express my support for changes to Senate File 87, Voyeurism, with regard to penalties and definitions. First, I'd like to thank Senator Cost for bringing this forward again this year and thereby acknowledging this is a problem. Last year, Representative Crank from Kemmer brought this bill forward for amendments at my request, and the House Committee agreed unanimously that this law should be changed. However, due to some issues in wording, the amendments were pulled in Senate. You will see my face today because I believe that the shame of voyeurism belongs to the perpetrator, not to me or any other victim. Chairman Olson, I hope that I can answer your question regarding what I believe is the purpose of defining intimate area, because this is something that I requested last year. In my opinion, there are 5 problems with the way the current voyeurism law is written. I testified before Senate a few weeks ago about the same law. I'm not going to go over exactly the exact same things that I went over in Senate. I'm sure you guys have the recording of that. And if you would like to listen to that, you could do so. The first problem that I see with this voyeurism law is what I call the Cowboy Hat Dilemma. And this is the reason that the intimate areas needs to be defined. The current law states that a person is guilty of a felony if he uses any image recording device to observe another person under their clothing without consent. The specific parts of the person is undefined. So it could be argued that it is equally felonious in Wyoming to take a picture of a rear in a skirt as to take a picture of the eyes of a cowboy wearing a cowboy hat. The second problem stems from this first problem, that is constitutionality. It is unconstitutional to use a law that is written in such a vague manner or undefined manner as to make legal activities illegal. A rogue county attorney could potentially charge someone they don't really like with taking a picture of their neighbor wearing a fedora, and this would be a felony. Or a person who is currently imprisoned under the law could potentially get their conviction overturned based on the unconstitutionality of the current law. The third problem is lack of consequences. At the Senate committee meeting, it was revealed that sneaking into a locker room and recording naked people has a lesser consequence in Wyoming than sneaking in and recording a conversation between 2 strangers about the weather. My understanding is that both of these activities are felonies and that the penalty for the conversation would be 5 years. The fourth problem is lack of clarity. When I encountered a voyeur taking a picture up my skirt in a grocery store parking lot, the incident was caught on camera. Prosecution was declined based on the fact that I was wearing underwear. Therefore, the image did not meet the requirement of under the clothing, and it was also not in an enclosed area. Prosecuted. But one thing is clear, many hours of law enforcement time and effort was wasted due to the vague nature of the current law. The fifth problem is the age of the law. Our current voyeurism law is 16 years old. We all know that it has become increasingly easy to take and distribute voyeuristic pictures. 16 years ago, we were dealing with people taking pictures, having to find a way to get pictures developed, paying for each print, and personally distributing copies. Now we are dealing with people being able to take nude pictures and distribute them potentially to thousands of people within a matter of seconds. The stakes are much higher now for victims, and so the stakes need to be much higher for perpetrators. It is time, in my opinion, to clarify what voyeurism is and is not. It is also time to increase penalties for people who engage in voyeuristic activities. I support putting these voyeurs on the sex offender registry. I came here last year, so some of you may remember me. I am here again today to see if we can make some changes. It has been 5 years since that day at the grocery store. Please let me know that I have been heard.
Questions for Ms. Petrie? Well, thank you for your testimony. We appreciate you sharing. We'll go to Mr. Barron now. Mr. Barron, go ahead and introduce yourself and let us know what you think.
Thank you, Mr. Chairman. My name is Joe Barron. I'm a Cook County and prosecuting attorney. I'm here on behalf of the Wyoming County and Prosecuting Attorneys Association. We speak in favor of this bill going forward. There is, having said that, there are some issues with the bill that have been raised that can be clarified. I'm sure Representative Oakley will bring those forward, and I'd just like to clarify a few issues on this. On page 2, line 5 and 6, if you are looking at removing consent of the person being viewed out of there, there's a phrase in there that you could remove for the misdemeanor offense on that. Then the next thing that you get into is the felony offense, which starts at line 20. And that goes through that indicates a 2-year felony for that particular offense. And they are correct. The statute, it's a 5-year felony for intercepting oral communications and electronic communications. So frankly, at a minimum, on line 22, this should at the very least to be, and this is actually a more egregious case than the others, but at a minimum, you may want to raise that up. And when I say that, just say not more than 5 years, $5,000 for that. You may want to consider that on line 22. With regard to the next page there, where you're talking about the consent there, and I would say it would seem to me like this is rather very restrictive on this particular felony. And what I would recommend is that on line 7, at the end of line 7 there, that you would insert the word or. Then you would go down there and then you would have B, under the clothing, or B, under the clothes being worn. So if you put those together, the way that's termed right now, you have to do A, B, and C in order to get a conviction. You have to prove each one of those elements. And it seems to me, let's not restrict this to just being under the clothes. We have recording of intimate areas, or using a camera or other image recording device under clothing being worn by another person. And then since this is a felony, and I know that without the consent of the other person, frankly, whether you put that in the language or not, normally consent is a defense to most crimes within the state of Wyoming on that. The other thing is down there where line 20, page 3, where it says not less than 5 years, but there's not a greater than. You're going to have to change that to, and I would suggest that at the very least, that you change that to not more than 5 years, but I would suggest that you raise that to 10 years. For example, a felony bad check case, over $1,000, the fine and penalty for that is like 10 years, $10,000 for any kind of a theft crime and a property
Mr.
crime.
Barron, sorry,
Yes.
I got sidetracked in a conversation. I want to make
Okay.
sure I'm listening to you. So on page, when you're on the 10-year, are you talking about page 3? And
I'm talking about,
the line 20 for the minor?
Mr. Chairman, yes, I am.
Okay, thank you. I'm with you now.
And I would say not more than 10 years on that, and $5,000, $10,000, either one. 10,000 is just a general felony. For example, a theft charge is 10 years on that. Now, and I just want to point something out to the legislative body here, is that this is the law, is that even if you have a mandatory minimum and maximum sentence on a particular offense, say you have a 2 to 5 or whatever it is on this, a judge can still grant straight probation on that particular offense, even though there is a mandatory minimum. It doesn't happen. I don't believe I've ever seen that happen, but I'm just telling you, under existing law, I believe that that's the case. The other thing is on this is that is this other thing down here now on page 4, 1 through 7, that appears to be a D on that. This says, and I think it should say something in here, this section, the section refers to the entire statute, I believe, on that. And so you may want to change that 5 years on that as well. It doesn't, if you're looking at just the adult part and not the misdemeanor part here, I think you need to say this subsection. You'll have to have your wordsmiths at LSO tell you how that goes. The other thing is, I want to point something out here. If a person is sentenced to the penitentiary and they actually go to the penitentiary, they don't get a split sentence and they don't get probation, then a judge does not have authority to place them on probation. Once they are sent to the Department of Corrections, then they come out and they're governed by the parole board, and as they parole out early, as Chairman Olson indicated, that, you know, if you get a 5-year sentence with good time and all that stuff, they might be out in 3 years, but then they have that other time after that that they can place them out on parole, which is similar to probation. It's the same probation and parole agents that govern those things, but the courts don't govern that. That's governed by the parole board, and county attorneys and prosecutors have no say in what goes on there with revocations or anything like that. And so I'm thinking in part what this may relate to on starting on page 4, line 9, may relate to the misdemeanor offense as it was started there, but yet that doesn't make much sense, because then you have this video segments and clips. You're talking about video down here on line 18. And so it seems kind of incompatible, but if a judge does put them on probation, I think that shall probably needs to be turned to a may in that particular issue. And then the last thing that I'd like to address is this, is the placement on the sex offender registry. As regard to that, the way that happens is a judge does not do that. The legislature has determined what crimes people have to register for. And that, I believe, is set forth in 719-303. So the legislature could add this particular crime to that list of offenses that are set forth in the registry. And based on where you put that, then the legislature would just include this on all the other crimes that are required to be registered for within that. And it's considered civil in nature, and therefore the criminal court doesn't have any say in it. And if you have any questions, I know I went through a lot there, but that's the, if you have any questions, let me know.
Thank you, Mr. Barron. Yeah, you did go through a lot, but what I found amazing, Mr. Barron, is that you and I agreed on everything you just said. It only took us 2 weeks to get there, but we're there. Thank you.
Thank you, Mr. Chairman.
Representative Williams.
Thank you, Mr. Chairman. Thank you, Mr. Byrne. Looking at page 3, lines 5 through 7, just kind of a technical question about some of these words that are used, observing, viewing, photographing, filming, recording, or videotaping. Do you foresee the need to add live streaming in there, or is what's listed in there covered?
Mr. Barron? Would streaming be different than, I guess is that different than recording by definition? I guess it's just
Well,
recording means by definition.
Mr. Chairman, I suppose you could argue that if it's live stream, it's not recorded. I don't think it hurts anything to put it in there. And people will always come up with something new tomorrow. And so I think it's good to go ahead and add that.
Yeah, and probably covered under filming maybe, but filming is an archaic word maybe now because we don't have film. But I think I see the point. So to clarify one thing you said, Mr. Barron, on the sex offender registry, under 7-13-302, filming of a minor, that's a separate statute, not in this bill right now. That's a statute that I think lists off offenses that are automatic on the registry, which is what you're referring to, that we as the legislature have a statute that says if you commit the following offenses, you're on the registry. On that list, I believe, is an offense of voyeurism when the victim is a minor. So if we wanted to include any part of the voyeurism statute or just the felony provision, either way, whatever I guess the committee decides, would it make more sense to just add this to the list of 7-13-302 instead of having this 7-13-304? Just put it on the list of that we already have.
Mr. Chairman, I believe it would in the statute. I think we're referring to as 719.
Oh, 19.
Sorry, this is always they're long statutes. And so I can't just immediately glance at it and tell you, I think it's in 719-302
Okay.
is where the list of statutes are in that. But it would, yes, I believe that would be the best way to handle that.
Perfect. Committee, other questions for Mr. Barron? Representative Oakley?
Thank you, Mr. Chair. Good morning, Mr. Barron. I guess I just wanted to ask you, my thought, I've flagged the same issue. I think all of subsection E creates two separate punishment provisions, and I think they're conflicting. And so while I understand, and, we kind of discussed the intent, the reality is that's part of, if they get out on probation or parole as part of sentencing discretion. So that's already covered in all of the other previous and necessary punishment sections. So I guess my thought is to completely eliminate section E. And I just was, since you're here, thought I'd see if that's the solution you've arrived at as well.
Mr. Barron?
Chairman Olson, Representative Oakley, I believe that would be the solution in this particular case. If a judge is going to grant probation, then they've already have the authority to do all of those things. And right now, under these felony provisions, the minimum, the standard probation right now is 3 years of supervised probation if somebody is placed on probation. I would suggest one thing there is that perhaps in the misdemeanor language up there in subpart A, that as we do, like say in the DUI statute and a couple other statutes, we expand the term of probation, say up to 3 years, in that particular statute. Because normally the way it works, as you well know, is the term of probation cannot exceed the maximum sentence for a misdemeanor unless there's a statute that allows otherwise.
All right. Thank you, Mr. Barron. Other questions for Mr. Barron? All right, thank you again. If you're out in the virtual world and you're wishing to testify, raise your little hand. Do I have anyone in the room? Mr. Odekoven, please come forward. And I got a couple in the virtual world with hands raised. Anyone else who's going to testify in the room, I would just say at this point, let's try not to go back over anything that we've already been. I think we're making really sharp progress, and I want to make sure we have enough time to work the bill and hopefully open up some time on our second bill. So I think we're on a good trend here. So let's just not be repetitive. Go ahead, Mr. Odekoven.
Thank you, Mr. Chairman. Byron Odekoven, the Executive Director of the Wyoming Sheriffs in Chief, rising in support of the bill. So let me bounce rapidly through a couple of key points rather than do a kind of an introduction, so to speak, because I think you're correct. Your time is better spent on working some of the issues that we've already identified. So this is an issue that's very frustrating for us as we see the disparate treatment between what exists in statute, this offense, and other sexual related offenses. I would remind the committee of a couple of key points. And I appreciate the sense of seriousness and frustration as we're working the bill, because it also points out to us some of the frustration we have in the disparity with other statutes and the conflicts and the general trends we see going. If I remember our presentation last week on how the desire for the legislature is to reduce sentences, reduce prison time, reduce probation and parole time. Likewise, with budget cuts, I would hope that at some point during the discussion, you would ask the Department of Corrections if they're even offering sex offender management or sexual perpetrator therapy at the moment with the budget cuts. As I understand, that was the last thing on the table to be cut, and I haven't checked lately if it was in fact cut. So your question of who pays is very relevant. With the offender, generally they don't have the ability. With the state, not without a budget. So that is of issue. Likewise, you've reduced the amount of time people spend on probation. Again, this points to the seriousness of these kinds of cases, that the one size fits all doesn't necessarily fit all crime, is my point, Mr. Chairman. Third, I would also ask, as you look at the treatment modality and therapy options available, because we also believe in early intervention. If you can intercede, intervene, correct behavior in the early stage, you'll avoid that long-term behavior issue at some point, which is very important. But if I remember correctly, the therapy treatment that's recommended exceeds the current time you would spend in jail, given the fact that you've granted the ability for jail time to be reduced. You do the day for day, you do the good time, you do all of those things. That 5-year sentence, as we've already talked about, is now 2.5, maybe. And our therapy time, if I remember right, was 3 years minimum, 5 years probable. So you're releasing a person before they can complete the treatment you want them to receive. So how do we expect them to be successful and not reoffend? So the point is, as I say, one size doesn't necessarily fit all in our criminal justice discussion. We may need to take a more serious look at some of that treatment to ensure success and proper supervision to ensure that they don't reoffend, when in this case, the testimony of one of our witnesses indicated a multi-year crime spree involving thousands of issues coming to light once. And we need to get our treatment, our sentencing, our whole treatment of that offender done well. Mr. Chairman, I could go on for a while, but I think I should quit there.
Mr. Odekoven, you just drove the point home, I think, on the felony, which is that, one, you can compare the felony to other felonies and it doesn't make any sense. But if we're really focused on wanting treatment for these offenders, a 2-year, the 2-year sentence after they get day for day, good time, and they serve a little over a year and they're out, we're not getting them the treatment that they need. So would you agree that making that, I know Mr. Barron said 5 years. Is it, I don't know what the magic number is for that, but it sounds like if the treatment is 3 to 4 years, we want at least a 4-year sentence to be able to get most of that treatment. And if you basically serve just over half of your sentence, we would actually need 5 years to get 2.5 years, maybe 3 years on the actual sentence.
And Mr. Chairman, I would agree, and with the caveat that I would want to see what the current recommendation is for that treatment modality to be successful. I would not want to say that we're banking on 2.5 years when 3 years is the magic number, kind of a thing. Please, I don't have a clear answer for you on that. And like I say, it's difficult when you look at the normal other sentencing and then we tweak this to a specific sentence, makes it somewhat difficult. But I think Mr. Barron's point is well founded in that unless you specify that length of time for probation, it can't be as long as you were thinking it might be. So there's some specificity there you may want to deal with in order to make this a good bill.
And Mr. Odekoven, I'm just trying to find the place to rest the felony. I had written down 4 years when I first saw the bill. I liked Mr. Barron's proposal of 5 years. Do you have a preference between the 4 and the 5 years?
Mr. Chairman, of course I would go for 5. That would allow, and I say that not because of the 5 years in jail, because again, it's the 5 years under the court supervision.
Sure.
The court can determine that difference and the court can prescribe that treatment. But if you say it's 4 years, they only have 4 years to accomplish that. If you say it's 5, they have 5 years to accomplish that. That's the point.
And do you see any issue at all with, I mean, if the legislature already defines who is a sex offender in terms of registry and who isn't, is there any issue with listing these felons under the registry?
Mr. Chairman, at first blush, I would answer no. I would not see a problem with that.
And what about the misdemeanors?
And the misdemeanor, you have been reluctant to list misdemeanors on the sex offender registry. That's a very sensitive topic that you have wrestled with before. You have been reluctant to do that. This may be the impetus to relook at that. Again, not all misdemeanors are created equal, so to speak, and you may want to look at that. Likewise, you may want to also look and ensure that you don't accidentally include this crime that you're contemplating in the list of those you just approved to have their record automatically expunged. Or expunged in that short period of time.
It's not automatic, that bill's not
Sorry,
automatic expungement.
Mr. Chairman, yes, it was made a little easier to expunge, I guess. So you need to make sure that this is not one of those that is in that process of the fast track of having it expunged, as we've already heard of this multi-year issue that seems to go on. We may have them being first offenders several times.
We'll put that on Senator Cost's radar when that bill is heard in the judiciary to make sure that maybe these folks aren't included or are included. I suppose it's up to you, but take a look at it. Representative Williams.
Thank you, Mr. Chairman. Mr. Odekoven, quick question. Technology is ever evolving. In regards to this bill, do you think there's plenty of coverage as far as what is captured specifically on page 3? I'm just thinking of drones and other types of technology out there. If you can just kind of speak to that.
Mr. Odekoven.
Mr. Chairman, I would hope that you would drive on the language that is inclusive, far-reaching, and broad, because you are correct. The type of technology that we contemplated even the last time this bill was heard doesn't match what I got posted on Facebook to look to see how small the camera can be to do, to place, to hide, to involve with. So whether it's in the sky, on the ground, or plugged into the wall seemingly innocently, there's lots of options out there for some folks to do some nefarious activity with, Mr. Chairman.
That's a good question. I mean, in San Francisco, they banned drones on the beach. So somebody put a camera on a kite and flew it over the beach and it wasn't a drone. So, I mean, it's a great question. You just have to constantly battle with, there's always going to be a loophole, I suppose.
Our goal is to not have a loophole in the beginning, Mr. Chairman. Thank you.
Representative Zwanitzer.
Thanks. And it's probably an unfair opinion question, but the bill was heard last year and didn't make it. I didn't quite have not heard what was so wrong with it last year that it didn't make it through. And maybe that's for Senator Cost as well, but what have we fixed from last year that has assuaged everyone in the Senate, or what was the problem last year that it didn't make it, if you can remember?
No, that's actually a great question, because when I went back and looked at the bill, and I remember where the conference committee was ending, and then I look at a unanimously flying through the Senate, and I'm wondering what's changed in the Senate, so that when in contemplating all these amendments specifically, we don't want to lose, but I also think we have an opportunity to send the right message at the right timing and button up this law. Do you know, Mr. Otakoven?
Mr. Chairman, without being slightly interesting answer, there are several things that happened in the last few days of the last legislature that I'm still shaking my head at, wondering why and what they thinking. And I think this is one of those moments where I'm going, what was wrong with this? It was a good bill. And there are days I still wonder what happens on the last days of the legislature, Mr. Chairman, with all due respect.
Senator Cost, we won't make you answer what went wrong with capital construction bill on the last day, but with voyeurism, maybe? What do you know?
Oh, I appreciate that, sir. The definitions are more precise than they were then, and that's really where everybody was falling down. The argument on the floor was that they just didn't feel that it was defined well enough, so.
All right. Thank you,
Mr. Chairman, thank you. With all due respect, I'd like to go back to my seat so you can work the bill so we can get to the next bill that I want to testify in favor of. So thank you, Mr. Chairman.
Thank you, Mr. Otakoven. Tara?
Good morning, Chairman Olson. Thank you for giving me just a minute. I'll be brief, and committee members, good morning. We certainly support this bill. There's nothing worse when a survivor finally does come forward, because so few do. To be told, and Mr. Otakoven hit the nail on the head. It's so frustrating when the law will not have definitions that will cover what victims come forward with. So as difficult as last year's voyeurism bill was with the definitions, there were lots of opinions. I think this is the cleaned up bill with the definition. There are common themes that are frustrating everyone this year. So I just want to plant a seed before I jump off that. We always have a lot of trouble when we're either inserting intent language or taking it back out, because so many perpetrators of these kinds of crimes and others can easily get off because they just say, oh, I didn't mean any harm. There are some obvious examples with hundreds of thousands of photos is different. But having some kind of interim study on these kinds of sex crimes, what is effective treatment? Is the sex offender management or sex offender registry even working before we add more people to it? But having some kind of interim study around consent, what does that mean? Privacy, what does that mean? Yeah, maybe you consented to a photograph, but what rights does that give you for the future? And really looking at all our sex crime laws together, because there's just too many where that intent for sexual gratification is in these crimes, and all a perpetrator has to do is say, yeah, no, I didn't mean it that way. Ergo, I think it was a year or so ago in some of the news in our northern counties, someone gets groped at a bar, all that person has to do is say, I didn't mean it. And I'm worried that in several of the bills we're passing this year, which is great, we still need some longer time to look at all of the definitions. And I agree with some of the committee members. Wow, do we want that victim on the stand to have to talk about consent? Maybe we can have a longer discussion about how we bring safety to that victim when they do have to be on the stand or in an alternative setting. That's all I'll say to plant some seeds about what we could do this summer. And thank you for the time and for your hard work. I hope we can pass this bill. Thank you. Any questions, I'm happy to answer.
Thank you, Ms. Murr. Questions from Ms. Murr? Thank you. Let's move to Andrew Thomas. Go ahead and introduce yourself. If you represent an organization, let us know, and then let us know what you want us to know.
All right, thank you. Hello, my name is Andrew Thomas. I am a senior at Cody High School, and I'm representing Cody's Youth for Justice. Before speaking, I would like to thank Chairman Olson and the Judiciary Committee for letting me speak today. I am here speaking in favor of passing Senate File 87 voyeurism. I think it's pretty obvious that as the bill stands now without these amendments, that it's very vague in its wording, and it makes it extremely difficult to prosecute people for these crimes. And as a lot of you said, technology is advancing extremely fast, and it's only going to continue doing so. And so as that happens, it's made easier and easier for voyeurism to occur and for people to get away with it without prosecution. And so if we don't have these amendments, no one's going to get tried for this kind of thing. This needs to pass. A lot of people are victims of this and have not had justice. And I can imagine that that's extremely frustrating for these people. And back to the technology thing, and speaking as a student, I remember that when I was in middle school, there was an issue of students like sharing explicit photos of girls in our school. And that was pretty messed up. And I think that a lot of young men don't really think about that sort of, they don't think about that sort of thing. Their brains aren't developed. And so they just act by doing something stupid. If we increase the punishment for this kind of thing, I think it'll put in people's heads how serious this sort of thing is. And it could reduce happenings like that on for younger people. That is all I have to say. I really hope you consider passing this bill, as I think it would help our state be a much safer place. Thank you, and I can answer any questions you might have for me.
Andrew, thank you for testifying. It's always great to have young folks involved, particularly students. Really appreciate that. Not just watching the legislature, but getting involved on a bill, testifying on the bill, getting involved in the process. It's great to see. I got a 9-year-old daughter. I got obviously some younger kids, but my 9-year-old daughter was on spring break last week, and I didn't see her at the Capitol, and I thought I was going to. And over the weekend, I asked her, how come you didn't come and watch us? And she was, reading, hanging out, playing video games. And I asked her why she didn't come. And she said, Dad, I've already been to the Capitol enough. So the reverse happens with my kids. So I'm really excited to see when young people get involved in the process. So thank you, Andrew.
Yeah, thank you.
All right. Anyone else in the virtual world or in the in-person world wishing to testify on Senate File 87? All right. Close public comment on Senate File 87. Committee, what is your pleasure?
Okay, Mr. Chairman, I'll move the bill.
All right. Moved by Representative Zwanitzer. Seconded by Vice Chairman Washington. All right. It's Monday morning, so I'll wake the committee up now. Where to begin on some of these amendments? I think Representative Oakley, maybe some of yours one by one, but I'm assuming if I'm tracking, the first amendment is an easy one, which is page 4, lines 9 through 21, section E. And you want to delete it.
I do, she doesn't.
Mr. Chair, I would just include, it continues page 5.
Oh, I'm
1
sorry.
through 4 as well, but yes, and then I would.
It goes on to page 5 all the way up lines 1 through 4. Okay. So it's been moved by Representative Oakley and seconded by Representative Zwanitzer. Discussion on the amendment? Question on the amendment? All those in favor signify by raising your hand. All those opposed? That amendment carries. Representative Williams?
I have two amendments.
Okay,
Page 3, line, well, either 6 or 7, add live streaming.
okay, for the person of observing, viewing, photographing, filming, recording, maybe comma, live streaming.
Shall I
Or
proceed with
videotaping?
the second or just one
Oh,
at a time?
Representatives wants or seconded that, sorry.
Okay.
Oh, you want to do, yeah, let's do them one at a time unless they're
Okay.
related.
That's good. Question.
Okay, did you get that? Okay, perfect. Question on the amendment. All those in favor of the amendment, signify by raising your hand. All those opposed, that amendment carries. What's your second amendment?
Thank you, Mr. Chairman. Page 5, line 21, section 2, this act is effective immediately.
I like that one too. Seconded by Representative Larson. Discussion? All those in favor, signify by raising your hand. All those opposed, that amendment carries. How about the Representative Zwanitzer?
Page amendment, I'm not sure how friendly it's going to be, but page 3, line 20. I just want to change not less than 5 years to not more than 10 years. And I guess I'm not a huge fan of mandatory minimums, and I like a lot of judicial discretion, especially if this is an 18-year-old high school senior. I guess I need to wait for a second before I explain.
Seconded by Representative Provenza. Discussion?
Yeah, did she? Oh, great. I just think it's better.
Discussion, Representative Oakley.
Thank you, Mr. Chair. I would agree. I was going to say second, what Representative Zwanitzer just said. I don't know if now is the time for the discussion on it, but I'll go ahead. Doing a 5-year minimum is certainly something I think to consider. A little pushback on sort of the tone that we've had. The other 5-year minimum that I can think of is production or dissemination of child pornography. I mean, they're pretty big stuff usually by the time we're looking at a min, and you are talking about then a judge. We had probably the lowest level of a child pornography case. And the judge said, I take it as legislative intent when it's a minimum that it should be imposed. So, and then what happens is I think you might find it less used. What happens is, deals are made, and unless you go to trial, a different charge is found. So what you can do by coming really hard with punishments and certainly mandatory minimums is make it so the statute's less used, quite honestly, or drop to a misdemeanor. So I just want to open that discussion that we really are paying attention and thinking about what it means to include a mandatory minimum on this charge.
Which now, so, okay, but and so we're clear on the amendment. The amendment gets rid of the mandatory minimum. You're saying in the existing, what it means to have the mandatory minimum in the existing law. Okay. Just want to make sure everyone on page 3.
Yes, so I'm sorry, Mr. Chair. So that's why I said I didn't know if it was a right time, because so what the motion just made, of course, would be not less than 5 nor more than 10.
No. The amendment is striking less of
Okay.
not more than 10 years.
So
Getting
doing
rid of
it-
the mandatory minimum.
Yes, that's
why I was
and
trying to clarify.
Thank you. I thought he added just not less than 5 nor more than 10. I support that direction. Yes, thank you.
Perfect. Okay,
Could you read that one more time? How it should read?
line or page 3, line 20. Of not, strike less, insert more, than strike 5, insert 10.
Perfect, thank you.
This is a perfect amendment.
That was easy.
All right, now I think we're all on the same page with that amendment. Any other discussion on the amendment? All those in, Representative Provenza, go ahead.
Thank you, Mr. Chairman. Just quick question, and maybe this is just because this is where, we took out section E, so that other
Other mandatory
minimum
is
is
gone.
gone. So I'm good. Thank you, Mr. Chairman.
Cleaning this bill up. Not that it was a bad bill, Senator Cost. Please don't get me wrong. We're driving home what you wanted. I could sense it in you. All those in favor of the amendment signify by raising your hand. All those opposed, that amendment carries. Maybe two more. Representative Oakley.
Thank you, Mr. Chair. I'm going along with what Prosecutor and County Attorney Barron said. And so what that would be to add, I believe, I hope I'm doing this in the right place, page 2, line 19, to add afterwards, and a term of probation not to exceed 1 year would be my amendment, which what that does is allow a misdemeanor to have a 1 year probation.
I think Representative Oakley, wouldn't that go with just subsection A? Wouldn't it go up where we have the 6-month fine of not more than $750, and then we would include it right there?
We could, I think, trying to think back, that I've seen it when there is as a separate subsection
Oh, I
in
see.
other, like, it's both in the 301 and the DUI statute. And I don't have them in front of me, but I believe they're in a separate, I don't think that necessarily matters, Chairman. So if there's any preference, but it does need to be in there that it's, that it's allowed to up to a year if we want to increase it over a 6-month probation. So wherever the committee thinks it's fits best is fine with me.
Is there a second on the amendment for probation? Seconded by Representative Craigo. I mean, we don't actually, I don't think we have to have a strict preference on where it goes. We can let LSO figure out where it goes best, whether it's a new subsection or whatever.
If we can do that, it's great.
Okay. Let's pick a place to put it so it's easier for K. And then if LSO wants to adjust it, when I approve the standing committee, I can do that. So we're on page 2. What do you want to do? Which one? You want to stick with creating a new subsection, and it would be after 6. So it'd be 7. So we're creating Romanet 7. And Romanet 7 will read.
It
Doesn't work? No, because those are elements. Those are elements.
Go ahead.
Representative Craigo.
I would suggest we just create a new subsection B and make B C.
B should be a whole nother statute, in my opinion. It'd be easier if the misdemeanor was one statute and the felony was another statute. But we're not gonna mess with that right now, I don't think. So, okay, so on page 2, new subsection B. And subsection B would read.
A term of supervised probation may be imposed not to exceed 1 year. Something like that.
And then you would just read letter B to C and accordingly. All right.
That would be subsection B.
Correct.
Okay.
Yep.
So you have 2 Bs.
No. You'll renumber B, C. And then if there are additional subsections, it'd be accordingly re-lettered. This is the new subsection B.
Okay.
Okay. All right. For Representative Oakley.
Thank you, Mr. Chair. I don't necessarily have an amendment, but I just wanted some discussion, I guess.
We gotta vote on that amendment first.
Oh, I'm sorry.
All those in favor of the amendment signify by raising your hand. All those opposed, that amendment carries. Before you have some general discussion, let's see if there's any other amendments.
Mr. Chairman,
Representative
so
Yin.
because of that last amendment, we actually have to renumber the sexual offender registry because the sexual offender registry referenced the old B. So we just need to ask LSO to make conforming amendments for references to.
Well,
the B.
I think under that, are you talking about 7-13-304?
302G.
302G. Oh, because it's in the existing statute.
Yeah, so the sexual offender registry actually references that specific, this subsection B, if it's a minor,
Okay,
and then says that person goes in the registry. We need to get LSO to
gotcha.
re-reference.
I think they caught that.
Okay.
Hopefully. We'll double check it when it comes out. Just remind me. Other amendments? Representative Oakley?
Thank you, Mr. Chair. So I guess I don't want to be out of order. It's a possible, like, I want to have a discussion to see if I want to bring an amendment, I guess. So would that be appropriate?
Well, no, it wouldn't. I'm just kidding.
So
We get, actually, for purposes of, it's very likely your amendment's wanted, so maybe just make it and then, because it,
I'm not sure. So I'll tell
Well,
you, it's 713-304. We had this whole discussion. It just says it may require a defendant to complete a sex offender treatment program. Again, that's something that judges can do as far as probation anyway. So my question is whether we want a whole section and put that in statute or not. And again, really for discussion, I don't necessarily have it. That is already something that judges can do when they're doing. So
Right.
whether
So
it
it's
needs a
un-
whole section.
probably doesn't harm it if we can already do it. Sends a message, I suppose. I've been patiently waiting for this amendment on the felony. To up the felony. Page 2, line 22. 2-year felony. Representative Washington.
Your wish is my command. Motion that line 22 on page 2, strike the word 2 and then numeral 2 and replace with 5.
Seconded, moved by Representative Washington, seconded by Representative Williams. Discussion. Question on the amendment. All those in favor signify by raising your hand. Oh, all those in favor signify by raising your hand. All those opposed? That amendment carries. All right. Representative Washington.
Thank you, Mr. Chairman. I would like to see, I know that voyeurism is referenced in the sex offender registry law, but it's not mentioned in the definition of criminal offenses. So I think I would like a more of a conceptual amendment, ask the LSO attorneys to make the recommended changes throughout this bill and the sex offender registry statute necessary to make certain that this voyeurism is included in the sexual offender registry throughout.
And Representative Washington, are you talking about any offense under the voyeurism or just the felony?
The felony.
Okay, so maybe the way we do that is we reference 6-4-304B2. Now C2. That we want to put on the list of 7-19-302. Which I think is this.
I think so, but also in 719-301A, it seems like where it lists out the different criminal offenses, I think it may need to be included there. That's why I was asking.
Representative Crago?
Just quick discussion on this, Mr. Chairman. So I think we should also include not just part 2 of C, but part 1 of C, the entire felony provision. If we're going to include, I mean, that would cover, because otherwise we are not covering the person who sticks a camera in a hotel room or a locker room. We're only covering the personal,
right?
You know, we're only covering under the clothing, under the clothing part. We're not covering the circumstance where somebody sticks a video camera and has the whole locker room and it's not under clothing. That makes sense.
It does make sense. So I think this is a conceptual amendment, K, to include the felony of voyeurism on the sex offender registry. And we'll make sure we get that into the statute. Representative Yin?
Was that seconded? I just want to make
I
sure.
think Representative Crago seconded.
So it is already in there specifically for if it's voyeurism against a minor. I'm not comfortable with adding more people to the sexual offender registry, especially after we've had this long discussion about expungement, where it makes it harder for people to re-enter society. So my question is, maybe for the committee, where is the line from when someone is reformed versus not, and how well does a sexual offender registry work before we start putting more people onto it?
A lot, and Representative Ian, I do think that's a good point. I think whether it makes it there or not, it was raised that maybe it would be a good interim study to really study that registry and what are the effects of it. What do our recidivism rates look like with it? What do our offenses look like in general? What does life for those individuals look like in terms of getting back into society? I think those are long-term questions that probably not one of us has an answer to. I think the one question we can still answer today, though, is whether or not it is an offense that is worthy of being on the registry, that we want to keep it. The purpose of the registry is not to penalize, it is to keep people on our radar. So we know, so when we have somebody who has a thumb drive with thousands of videos on it, how many times did they go through the system, or are we even keeping track of those people? I think that's the only thing we can answer today. Vice Chairman Washut.
Thank you, Mr. Chairman. I just harken back to that powerful letter that we had from our victim, and she's an adult, I'm assuming, and we're in the workforce. So if we don't address adult victims and survivors in this bill, I think we failed to hear the message from that individual who was so poignant in testimony today.
Representative Oakley.
Thank you, Mr. Chair. I just would again say that while the intent of the sex offender registration may not be to penalize, it certainly has that effect. And it's something that people go to great lengths to avoid. And I'm just talking about the realities of it here. And it can be one of those things that then could make this less used. It's just a discussion when people go, I've had a judge push me to switch a charge. I didn't do it, but to try to say, could we find a different charge that wasn't something where they had to register? So it definitely is a big consideration for defendants in pleading and taking responsibility if they have to do registry. Just throwing that out there for discussion.
Ready for the question? Question. All those in favor of this amendment signify by raising your hand. All those opposed? Chairman votes aye. Amendment carries. That one's conceptual.
Could I meet with someone to get clarification on the changes on page 2 afterwards?
That's Representative Oakley's amendment?
Mhm.
Yes, Representative Oakley, when we finish up, can you get with Kay to help her with your amendment on probation?
Yes. Thank you.
Okay. Any other amendments? Substitute bill. All right, that's about enough. All right, Senator Cost. All right, question on the bill? All right. Kay, will you please call the roll on Senate File 87 voyeurism amendments?
Representative Crago.
Aye.
Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Williams.
Aye.
Vice Chairman Washut.
Aye.
Representative Yin.
Aye.
Representative Swanitzer.
Aye.
Chairman Olson.
Aye.
Mr. Chairman, you have 9 ayes.
We kept it unanimous for you. You're on a roll. I can't promise the same thing for our chamber. It is the House of Representatives. It's a little wild sometimes. Thank you, Senator Cost. All right. Senator Driscoll. I don't know if I left you enough time. 5 minutes. Okay, I trust you.
Mr. Chairman, thank you. Today I bring before you Senate File 155. It's a pretty simple bill. It's limiting firearm seizure and regulation and the keywords during emergencies. So this really, we've had a trend in some of the big cities to close down firearm sales, gun stores, gunsmiths, et cetera. This bill says that they've got to do with the same as they do with other business. Doesn't mean they can't do it. They've got to follow it in that fashion. It's an engrossed bill. The second part of the bill deals with the concealed carry permits and the shooting ranges, which turns out that down here, the city or the county operates a shooting range. And we had to amend the bill to make it so that it didn't have to be forced to where theirs was open all the time. Long and short, I stand for questions on it.
Yeah, my commissioners talked to me about that amendment over the weekend, so.
Yeah, and we wrote it right for them, with them, and it was done. So I think this bill's had good support across, and it's a pretty simple bill.
What's Representative Wanser?
Thanks. I just need to know, what's a personal weapon that isn't a firearm?
You know, it could be a knife or a, you know, et cetera type deal. That's
okay.
Mr. Chairman, Representative Wanser, excuse me. We're in a little.
Vice Chairman Washit.
Thank you, Mr. Chairman. Senator, do you know if personal weapons is defined somewhere in statute?
Chairman Olson, Representative Wassett, I do not. I could track that down for you.
No other questions, committee? All right. Thank you, Senator Driscoll. Public testimony on this bill. What is that? Thumbs up mean you support the bill or you want to testify on it, Nephi?
Foundation, I'm Nephi Cole, Director of Government Relations, State Affairs, and I support the bill.
Surprised me. Thank you, Mr. Cole.
Ryan Gosh, National Rifle Association.
All right, Mr. Odekoven.
Mr. Odekoven, Byron, long morning. Byron Odekoven, representing the Wyoming Association of Sheriffs and Chiefs. Supporting the bill, one additional small comment, and that is, since Wyoming is an incredibly small state, many of the gun shops are actually our gunsmiths. For agencies and departments, along with ranges as well. Many of those private ranges are our ranges. So yes, this would be near and dear to law enforcement's heart to make sure those businesses remain open and viable during an emergency. Mr. Chairman.
Thank you. Questions for anyone? No. County commissioners? No. All right. Do I have anyone in the virtual world, Clarissa, who wishes to testify on this Senate File 155?
Mr. Chairman, I don't see anyone with their hand raised.
Thank you, Clarissa. So we are on Senate File 155, limiting firearm seizure and regulation during emergencies. Anyone else wishing to testify on this bill? Close public comment on this bill. Committee, what is your pleasure? Moved by Representative Larson, seconded by Vice Chairman Washit. Discussion on the bill. What's that?
You want me to talk?
All right. Representative Yin is fine with the question. Question being called. And I guess you'll follow up with us, Senator, on that definition, maybe just in case we get that on the floor or might be helpful. Representative Wanser is not finding it in statute right now, but we can put it there. All right. Looks good. Kay, will you please call the roll on Senate File 155, limiting firearm seizure and regulation during emergencies?
Representative Crago.
Aye.
Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Excused.
Representative Williams.
Aye.
Representative Washut.
Aye.
Representative Yin.
No.
Representative Swanitzer.
Aye.
Chairman Olson.
Aye.
Mr. Chairman, you have 7 ayes, 1 excused, and 1 no.
Thank you, Kay.
Thank you.
Thanks, man. I'll talk to Cost about taking us 2 hours.
Who's carrying it? There's no house sponsor on it.
Brad, you got it done in 5 minutes.
Senator Driscoll, who's your?
Representative- We'll find someone to carry this, Senator.